Good evening and welcome back to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. I will start with the landmark judgment delivered by a 7-judge bench of the Supreme Court today regarding immunity for MPs and MLAs from taking bribe for vote or speech in legislature. In a unanimous decision, the top court, while overruling the 1998 P.V. Narasimha Rao judgment, has held that members of parliament and legislative assemblies cannot claim immunity under the constitution for receiving a bribe in contemplation of a vote or speech in the legislature. As you must be aware that parliamentary privileges under Articles 105 and 194 of the Constitution give members of parliament and state legislatures certain special rights and protections. These include freedom of speech and debate inside the parliament or the legislature without the fear of being sued or prosecuted for what they say. In the P.V. Narasimha judgment, a 5-judge bench of the Apex Court had held that legislators do enjoy immunity from prosecution in cases of bribery in relation to parliamentary vote and speech. However, it had added that the same would apply if the legislators carried out the act that they had taken the bribe for. In other words, if a legislator took a bribe to vote for a particular candidate but later decided not to go ahead with the same and voted for someone else, the immunity would not be extended to them. The main case here relates to Sita Soren, a member of the Jharkhand Mukti Morcha, who was accused of accepting bribe for voting in favor of a particular candidate in the 2012 Rajya Sabha elections. Subsequently, a charge sheet was filed by CBI. Challenging the same, Soren filed a petition before the Jharkhand High Court on the ground that she enjoyed immunity under the Constitution. But the High Court dismissed the petition. While her appeal was being heard before the Supreme Court, reliance was placed on the judgment in P.V. Narasimha Rao and it was referred to this 7-judge bench. In its verdict, the court has now said that Articles 105 and 194 aim to create a space for open discussion and decision-making within the legislature. This goal is compromised when a member is influenced to vote or speak in a certain way due to bribery. That bribery is not protected under these articles because it involves a criminal act that is not necessary for the functioning of voting or speaking in the legislature, and rather undermines the integrity of the legislative process. It was also held that the offence of bribery as per Prevention of Corruption Act is complete the moment the illegal gratification is taken, and it is immaterial whether the legislator votes or gives a speech later in the House in terms of the bribe. Do visit livelaw.in to read this judgment in detail. The Supreme Court today refused to entertain a PIL seeking directions to centre and state governments to consider reasonable demands of the protesting farmers and to allow the protesters to move to Delhi. The plea stated that protesting farmers were being treated unfairly by the governments. It pointed out that farmers from Punjab had been detained in disrespectful, harsh and aggressive ways for simply wanting to travel to Delhi in their private vehicles. But the bench expressed reservations about the manner in which the petition had been filed. It said that people should not bring such cases to the top court only for publicity purposes. The court also suggested that the petitioner should consider assisting the High Court where the matter was already pending consideration. The bench of Justices Suryakant and K.V. Vishwanathan permitted the case to be withdrawn, taking into consideration the petitioner's request to amend the petition. The Supreme Court today directed the Aam Aadmi Party to vacate its premises at New Delhi, which is earmarked for Delhi judiciary by 15th June 2024, so that land allotted to expand the district judiciary footprint can be used for the purpose. Solicitor General Tushar Mehta submitted that the land allotment to Aam Aadmi Party was revoked in June 2017 and at least since then it was an encroacher. Senior advocate Abhishek Manu Singhvi, appearing for the party, submitted that it was entitled to the land in Delhi in accordance with its status as a national party. That the alternate land which was proposed to be allotted to it was situated in Badarpur at the outskirts of the city. He also said that there were political malefites behind the decision. The court noted that the Delhi High Court urgently requires premises to accommodate new recruits, but there were not enough courtrooms available. Since the proposed MTNL building was deemed unsuitable, the court instructed the Chief Secretary of the Delhi government to propose an alternative within 2 weeks and to inform the Chief Justice of the High Court. Former Tamil Nadu Higher Education Minister K. Ponmudi has moved the Supreme Court against Madras High Court order setting aside his acquittal in a disproportionate assets case. A case was registered against Ponmudi and his wife by the Department of Vigilance and Anti-Corruption based on allegations that he amassed wealth disproportionate to his sources of income. This was alleged to have happened during his tenure as the Minister for Mines and Minerals in the DMK government from 2006 to 2010. The trial court had acquitted the pair, holding that the prosecution failed to prove the case. In December 2023, however, a bench of the Madras High Court found error in the trial court order and set aside the acquittal. It directed the ex-minister and his wife to appear for hearing on sentence. After being heard, the two were sentenced to simple imprisonment for 3 years along with fine. Challenging the High Court order reversing the acquittal, Ponmudi has now approached the Supreme Court. The matter came up today before a bench of Justices Abhay S. Oak and Ujjal Bhuya. His counsel pressed the prayer for interim relief of suspension of conviction. Being of the opinion that the matter needed consideration, the court has listed it for 18th March. The Apex Court has today issued notice in a plea by the Delhi government challenging the Lieutenant Governor's order that limits the government's freedom to choose its own lawyers for constitutional court cases and set their fees. A bench of Justices Sanjeev Khanna and Dipankar Datta was hearing a writ petition filed by the Government of National Capital Territory of Delhi against a 2017 office memorandum issued by the Union Home Ministry and an order passed by the Delhi Lieutenant Governor's Office on 16th February. Senior advocates Shyam Devan and Siddharth Dave appeared for the Delhi government. They contended that the elected government of NCT of Delhi should have the authority to choose its legal representatives. The right to select a lawyer of choice is highly valued, and the elected government should not be prevented from choosing its advocates for constitutional court cases. Justice Khanna, while issuing notice, suggested that this plea by GNTCD would likely be linked to its challenge against the 2023 amendment to Government of National Capital Territory of Delhi Act. If you remember, this amendment, among other things, removes the authority of the Delhi government to manage civil servants working within its area of authority. The Supreme Court today expressed displeasure at Tamil Nadu Minister Udayinidhi Stalin for his remarks about Sanatan Dharma. The DMK leader came under scanner in September last year for his remarks comparing Sanatan Dharma to diseases like malaria and dengue, while advocating for its elimination on grounds that it was rooted in the caste system and historical discrimination. This led to a huge political controversy, along with criminal cases being filed against him in 6 different states across India. A bench comprising Justices Sanjeev Khanna and Dipankar Datta was today hearing a PIL filed by Udayinidhi seeking to club the FIRs registered in Tamil Nadu, Maharashtra, Jammu and Kashmir and 3 more states. Senior advocate Abhishek Manu Singhvi, appearing for him, relied on the orders passed by the Supreme Court in the cases of Amish Devgan, Arnab Goswami, Nupur Sharma and Mohammad Zubair, allowing the consolidation of FIRs in multiple states, and he stated that he was only seeking the very same relief. When the bench questioned as to why a witness in the complaint in a particular state be asked to go to some other jurisdiction, Singhvi reiterated his reliance on earlier cases and also pointed out that the course of action in the FIRs was the same, emanating from the Tamil Nadu minister's remarks. The bench ultimately agreed to examine the plea and posted it to next Friday. The Supreme Court today agreed to consider urgent listing of the curative petitions filed by Aam Aadmi Party leader and former Delhi Deputy Chief Minister Manish Sisodia seeking bail in the Delhi liquor policy scam case. The curative plea seeks bail for Sisodia in connection with the scam, where he faces charges registered by the CBI and Enforcement Directorate. In October, a bench comprising Justices Sanjeev Khanna and S.V.N. Bhatti had dismissed his petitions seeking bail in the CBI and ED cases. While denying bail, the bench had stated that Sisodia will be entitled to apply for fresh bail if the trial does not progress in 3 months. Today, senior advocate A.M. Singhvi, appearing for Sisodia, submitted that the trial court has deferred hearing of his fresh bail application by saying that the curative petition is pending before the Supreme Court. CJI Chandrachud, acknowledging the urgency, agreed to consider the matter. A Delhi court has significantly held that women who misuse law to level false rape allegations must be dealt with strictly. In this case, charges of rape were framed against 4 men. It was the prosecutrix's case that she was raped initially by the accused named Satish and later on gang raped by other accused persons, and that Satish went on to blackmail her by threatening to send nude photographs and videos to her family members. But the court acquitted the accused. While acquitting them, the court observed that not only was the version of prosecutrix regarding her abduction and rape completely and patently false, it also showed her motive in filing the false complaint, as she had married Satish at the Arya Samaj temple in 2012 by concealing from him that she was already married. Additional Sessions Judge Jagmohan Singh of Rohini courts observed that the conduct of the prosecutrix was against all canons of prudence and made her testimony wholly unworthy of credit. Accordingly, the court ordered that proceedings under Section 344 of CRPC, that is summary procedure for trial for giving false evidence, be initiated against the woman. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.